So I guess we could probably begin. Hello, everyone. So we're going to be talking tonight about the concept of agreement in contracts. But before we do that, would there be any questions that you might have or anything that you would wish to raise before we start talking about the topic on agreements? Some of you may have noticed that as of Saturday, I actually posted already the legal memorandum assessment. So you could actually start working on it. So I got a message from Martin. Okay, so if there isn't any question, we could probably begin. So after studying this topic, you should be able to demonstrate a knowledge of the following concepts: the basic concepts of an offer and acceptance, the distinction between unilateral and bilateral offers, the distinction between an offer and an invitation to treat, special forms of offer, such as ticket machines, vending machines, auctions and tenders, the circumstances in which an offer can be terminated, the concept of ad idem, or the meeting of the minds, and the need for acceptance to be unconditional in reliance on the offer, communicated to the offerer, and so on. So let's begin by looking at the first tutorial question. Can I have a volunteer to read the tutorial question for us? Volunteers? Heidi, perhaps? Heidi, you mind reading the tutorial question for us? Thank you.
The Ponds Cosmetic Company claims to operate a scientific facility known as the Ponds Institute. Sorry. They also sell cosmetics in the United Kingdom under the brand name Ponds Institute. Claims about the scientific side of the Ponds Institute include claims that the company hires hundreds of scientists from around the world to develop new and innovative skincare solutions for modern women. Many individual Ponds products make claims relating to their efficiency based on what they claim to be the result of experience or research at the Ponds Institute. In this context, if the company was to claim that an anti-wrinkle cream will make you look 10 years younger in 10 days, would you regard this as a binding pre-contractual representation or as a mere puff? Are there strong arguments to be made on both sides?
Okay. Now, can I ask everyone to give his or her answer in the chat box? So the specific question there is, if there was such a claim about the ability of the anti-wrinkle cream to make you look 10 years younger in 10 days, would you regard that as a binding pre-contractual representation or as a mere puff? So in your answer, it should be yes, it's a pre-contractual representation, or no, it's a mere puff. Has everyone actually answered? Okay. Now, the basic question is, what is the distinction? Why do we need to distinguish between a pre-contractual representation and a mere puff? Why do we need to make that kind of distinction? Why do we need to make, I'm just chuckling about Martin's chat there. Why would, who wants another wrinkle cream that doesn't make you younger? Okay. So why do we need to make a distinction between a binding pre-contractual representation and a mere puff? Why is that important? Okay, it can be ignored according to Peter. What else? From Dominique. To determine if there has been an offer made for acceptance. Okay, how about the others? Why do we need to make a distinction between a binding pre-contractual representation and a mere puff? So from Amelia, to determine any legal ramifications of any, from Luke, so that we know if someone is legally bound or not. Can I get the answers from the others? So from Martin, he's answering it from a policy perspective, because otherwise, if every single mere puff, if every mere puff or every little advertising slogan were considered binding, you can just imagine the implications upon companies that put up advertisements. From Sophie, mere puff isn't a contract. Okay. So we're looking at this from the viewpoint of an agreement, and we know that you can only have an agreement if there is an offer and that offer has been accepted. And that's because to have an agreement, there must be an ad idem, or a meeting of the minds. So there's a meeting because there is an offer from an offerer, and there is an acceptance by that offer by the offeree. Now, when an offerer actually makes an offer, we make an assumption for that offer to be legally binding that the offerer had an intention to be bound in the first place. So as Luke pointed out, if it is a mere puff, there was no intention on the part of the offerer to actually be bound by the puff. So it is essential for there to be a binding contract that there must be an offer, and not only must there be an offer, that offer must have been based on a legal intention to be bound by the offer. So if there was no intention to be bound by the offer because it was just a mere puff, it was an exaggerated claim. It was based on an assertion that is unlikely to be believed in by people because it's really exaggerated. Then in that case, it can be said that there was never an intention to be bound in the first place. So therefore, it cannot be a pre-contractual representation. So it cannot be a binding offer. Okay, and from a policy perspective, as Martin said, if every single puffery were to be considered as a legally binding offer, then it will have a lot of implications on advertisers and companies who may wish to advertise their products. And they would then expose themselves to legal liability every single time that somebody feels that there was a breach of contract or a breach of a promise that had been the basis of the offer in the first place. Now, so in relation to the first question we had, the question was it a binding pre-contractual representation or was it a mere puff? But there is another distinct question there. Is it possible to argue that, and everyone said it was a mere puff, but is it actually possible for any of you to argue that it was more than a mere puff? Can it be argued that this statement actually represents a binding pre-contractual representation? And why would it be relevant? For example, as Michael pointed out, it must be viewed by a reasonable person. Why is that? So there seems to be something important to what Michael has stated here. Can anyone make an argument that this, in fact, constitutes a pre-contractual representation and is more than a mere puff? And on what basis can you make such kind of an argument? So if you were the lawyer for a customer who felt aggrieved on the basis of a breach of contract because the person then felt that he did not look 10 years younger, how can you possibly make an argument that there was in fact a pre-contractual representation? Aha. So from Peter, hundreds of scientists. Oh, Peter, can I ask you to explain that? Why might that be relevant?
they're trying to say that by employing these hundreds of scientists, the claims that they are making are based on a scientific premise.
Something's wrong with the mic of Peter again. Okay. I think we got the gist of what Peter was saying. That there is, in fact, a view or a knowledge on the part of most consumers that Ponds is made up of or employs hundreds of scientists from around the world who are actually in a position to develop new and innovative skincare solutions for modern women. So if you have that as a fact or as a common knowledge to a reasonable person, it would then be possible for him to have the view that that claim is in fact real, that claim is in fact backed up by science or is in fact based on research by scientists. So you will notice, therefore, that when you look at what constitutes an offer, you don't just look at the statement itself, but you look at the context in which the offer is made. And you look at the offerer himself or herself or itself. So these are factors that will allow you to determine whether it's a mere puffery or it's in fact a binding pre-contractual representation. So in other words, if the offeror had not been Ponds, but let's say a teenage sensation, or it could be Justin Bieber, making a claim that he had come up with a fantastic anti-wrinkle cream that will make you 10 years younger in 10 days, you'd probably arrive at a different conclusion, wouldn't you? Okay, so in other words, when you look at what constitutes an offer, and for you to determine whether it's a pre-contractual representation, which means it becomes binding, or whether or not it is a mere puff, you look at the context in which the offer is made. You don't just look at the actual offer itself or the statement of the offer. You're looking as well at the person who made the offer. Yes. So as Martin pointed out, if you go by the case of Carlyle, it was just more than making a claim. They actually put some money in the bank. So that actually represented on the part of the company of the balls that were meant to cure the flu, that they were serious in their claim that using those balls for a period of time would actually prevent you from having flu. So you look at the context itself as well. Now, let's go back to this notion of a mere puff. Why would you say that that is a mere puff? Why is that a mere puff? Why would a claim that it would make you look 10 years younger in 10 days be a mere puff? So for example, if Toyota comes up with an advertisement saying that their cars are safe and that even if you were to have a collision, chances are you will survive the collision, would that be a mere puff? Or as Heidi pointed out, it is an attempt to entice you. The mere fact that an offer is meant to entice you, does it mean therefore that it is a puffery? Is it the fact that it is meant to entice somebody? Does that mean that therefore it is a puffery? So why would you say that this is a mere puff? So from Sophie, it depends if they offer reasons as to, so Emilio, so from Sophie, because you can't see the evidence. So are we suggesting, for example, that for something to constitute a binding pre-contractual representation and not a mere puff, you actually need to ask for evidence? But what if it's an advertisement in the first place? Or it's not a bilateral contract, it's what we would often call a unilateral contract or a unilateral offer, or one that is offered to the rest of the world. In which case, it is difficult on the part of the public to actually demand that there be proof or evidence of any offer that is being made or any claim that is being made. So here we have from Peter, it's an unrealistic claim. And from Jessica, because 10 years younger can't be measured. It's totally subjective as opposed to literal that's coming from Michael. So if you look at these comments from Michael, from Jessica, from Chrissy, because it's not possible, from Peter, it's an unrealistic claim, you get the sense that on the one hand, a claim that the anti-wrinkle cream will make you 10 years younger in 10 days. In the first place, it seems to be an unrealistic claim. And two, it could be quite subjective. You know, how are you to say that somebody has now looked 10 years younger? And it seems to be quite difficult to believe that an anti-wrinkle cream can actually make you look 10 years younger in 10 days. So all of these taken together would show that there seems to be a lot of exaggeration, a lot of puffery, you know, adding, making representations that are unlikely to be true. And that, therefore, those would constitute elements of what can be regarded as a puffery. Would there be any questions before we move on to tutorial question number 2? So we're good. Okay. Now let's move to the second tutorial question. Hold on, I'm just gonna reduce the font size. Hold on. What happened there? Sorry. Wait, I ended up pressing the wrong button. Give me a second. Okay, so we have the second tutorial question. Can I again ask someone to read the second tutorial question for us? Any volunteer? Dominique, are you able to read the second tutorial question for us?
Not on the screen.
I'm sorry?
It's not on the screen.
Oh, sorry. Okay, hold on. Yep, yeah, that's right. Hold on. Okay, there, it should be there. Okay. Can somebody read the question for us? Luke, perhaps, or Dominique?
Yeah, I'll cover it.
Thank you.
That's right. Graham is a slightly dodgy tyre merchant with a small workshop in an outer suburb. In his showroom, he has a series of tyres on display with prices and technical specifications next to them. Jill, who needed 2 new tyres on her car, came into the showroom, made a selection, and went to the desk. When she asked Graham to replace the 2 tyres in the car, he responded by telling her he could do a special deal by giving her 4 of those tyres at a lower price per tyre. Jill said, "Look, for the moment, just replace the 2 tyres and I will check my finances, then get back to you about the other 2. Graham responded, "Okay, but I'll need to know before midday if you want the 4 tyres to be done." At about 10:30 a.m., Jill still had not responded regarding the 3rd and 4th tyres, and Graham had the opportunity to sell the last of his stock to another customer. He did so. He sent a text message to Jill to say he now only had 2 tyres to sell her, but she did not receive the text message due to delays in the mobile phone system. Before she received the message, she phoned Graham and left a message on his answering machine to say that she wanted him to replace all 4 tyres. In relation to this scenario, A, is there a contract between Jill and Graham? B, who is the offerer and who is the offeree and why? C, do any of the facts suggest an invitation to treat? D, if there is a contract, is it for the replacement of 2 tyres or 4? And E, was Graham's attempt to withdraw his offer successful? Why or why not?
Thank you, Luke. Okay, I'm going to give you a minute to kind of digest this tutorial question, and then we'll start answering the different questions that are part of the scenario. So I'll give you a minute to just digest what the question is about. Okay, so I think we could begin answering the question. So let's begin by answering the first question there. Is there a contract between Jill and Graham?
I would say yes.
Okay. So put your answer there, yes or no. Aha. Okay. Aha, good. Okay. Now, can somebody explain to us what exactly is the contract between Jill and Graham? And that's actually related to question letter D. Would somebody like to take the floor? I could hear you. And who might that be?
Yeah, there's a contract for the replacement.
Is that Martin? Is that you, Martin?
It is. Can you hear me?
Yeah, I could hear you. Yep, go ahead.
Okay. I'm saying there's a contract for the replacement of 2 tires, but not 4.
Okay. Thank you. Now, why is it essential for us to be able to characterize the existence of a contract? Why is it important for us to conclude that there is a contract in the first place, at least in relation to the 2 tires? What is the significance of that there is in fact a contract?
Because if there's no contract, they're not bound.
What was it? If there is no contract,
then they're not bound to perform that contract.
Okay, but in that case, what exactly are they not bound to do? So if
well, he wouldn't have to pay for the tires, and he wouldn't be bound to fit the tires.
Okay, so what exactly was the offer here, and what was the offer that was accepted?
But by the looks of it, the offer that was accepted was for the 2 tires. The problem comes in that there also seems to be a counter offer, but she then made another offer for just the 2 tires, but he leaves the first offer open.
Okay, so if we assume, thank you, Martin. So if we assume that there is a contract, or let's assume that there is no contract, even for the 2 tires, the implication is it would have been possible actually for Graham to sell all the 4 tires. That would be the implication. If we assume that there is in fact a contract in relation to the 2 tires, then Graham would be in breach of a contract if he ended up selling all 4 tires. So that's why it's crucial that we establish a conclusion as to whether or not there was in fact a contract in the first place. So clear enough. Now, and then we will try to determine why it was a contract for 2 and not 4 as we move on to the other questions. Now, question B is, who is the offerer and who is the offeree and why? And, related to that question is, why is it even necessary for us to make a distinction as to who is the offerer and who is the offeree? So let's begin by answering that question. Who is the offeror and who is the offeree? Should get an answer here from Amelia. Initially, Jill is the offerer, offering to purchase 2 tires from Graham. Yep, upon the offer, Graham made a counter offer and becomes the offerer in relation to the 3rd and 4th tires. Very good. From Sophie, Graham is the offeror. Jill is the offeror. Wait. Something skipped. Okay, so from Sophie, Graham is the offerer and Jill is the offeree. Okay. So, before we figure out really who is the offerer and who is the offeree, why is it important for us to determine who is the offerer and who is the offeree? Why do we need to make that distinction? So why is it important for us to distinguish between the offerer and the offeree? Why do we need to determine whether or not it's actually Jill or Graham who is the offeror? I'm just going to have to turn off the mic of everyone else because I'm hearing a lot of strenuous noise. I could find the button. Okay. Yep. Got it. Would anyone wish to provide an answer? Aha. Okay. So we've got an answer here. So I'm actually reading the answers for the purpose of those who are just going to be viewing the recording later on, so they don't have to go through the chats. So from Tim, to determine who is bound and how, if at all. From Sophie, because who is bound, what? And from Luke, so we know who had the ability to withdraw the offer if you want it. Outlines who now needs to provide acceptance. Okay, so we've got kind of various answers there. Why do you suppose is it really crucial for us to know who is the offerer and who is the offeree? Can somebody take the floor? And you're gonna have to press the mic button there, so you're able to enable the mic, and then you can use the mic. Why is it crucial to make a distinction between who is the offeror and who is the offeree? Okay, different terms and conditions apply to each role. Okay, still quite vague for me.
Because you need to ascertain who accepted.
Who's that?
Tim.
Tim, okay. So can you repeat that for me, Tim?
If you didn't know, if you didn't identify the offerer and the offeree, you wouldn't be able to determine who accepted.
Ah, okay. So there are two parts to it. One part is, it is the offeree who makes the acceptance, right? And that's crucial because you need to know if an acceptance had in fact been made. What is the other aspect to it? Why is it crucial to determine who's the offerer and who is the offeree? So that's one of it. That's one of the reasons why we need to make the distinction, to determine whether or not an acceptance has actually been made by the offeree. But what's the second reason why we need to make the distinction?
Well, the opposite, you need to know if they hadn't agreed, or if the offeree had not agreed.
Somebody actually provided the correct answer here in the chats. From the viewpoint of the offeror, what power does he have? So the offeree has the power to accept it. What is the power of the offeror?
I think the offeror has the ability to withdraw it, but they need to do so correctly.
That's right. So we see, therefore, that the two have different roles. So as far as the offeree is concerned, the offeree is in a position to accept the offer. And if the offeree accepts the offer, you have a binding contract. So there's a meeting of the minds. You have ad idem. From the viewpoint, on the other hand, of the offeror, for as long as the offer has not yet been accepted by the offeree, then he has the right to withdraw the offer unless there has been consideration for that offer in the first place, which means that if there is a consideration, for example, then he may have to follow the initial contract that might have been there, which means that he cannot just unilaterally withdraw an offer. But generally speaking, in the absence of a consideration, the rule is that the offerer has the power and the right to withdraw an offer prior to its acceptance and conditionally by an offeree. Now, let's move on to the third question. Do any of the facts suggest an invitation to treat? And before we do that, before we answer that question, what exactly is an invitation to treat? So can I just see some answers in the chat box there? What exactly is an invitation to treat? Okay, so what exactly is it? Amelia, so what do we mean by an invitation to treat? Okay. So we've got an answer here from Martin, which is kind of the more accurate one. It is an invitation to make an offer. So when you say you have an invitation to treat, you're actually inviting other people to make an offer or to negotiate. So in other words, because if it is an invitation to treat, it is not an offer. It's not an offer in the sense that it is susceptible to be accepted, which then leads to a contract having been formed. So when it is simply an invitation to treat, the acceptance of that invitation will not lead to the creation of a contract. Because all it required, all that it actually entails is that it is kind of an invitation to the rest of the world to make an offer. So even if that invitation is accepted, that does not lead to a binding contract. So going to that question, do any of the facts suggest that the statements here constituted nothing more than an invitation to treat? Was there anything in any of the offers or maybe perhaps counter offers that would allow us to think that there was in fact an invitation to treat? And if that is so, where exactly there in the facts or in the scenario is the invitation to treat? The display of tires is an invitation to treat. What does it mean?
Is it because they have the prices and technical specifications with them, with the tires?
So are you suggesting, for example, Amelia, that Graham had an invitation to treat in relation to the tires?
Yes.
Okay. So if somebody said, I am getting these tires, was there a contract at that point when somebody said or a customer said, I would like to take these tires? Was there
only when they go to the counter?
Aha. Okay. Any other views on that?
So when Graham responds, okay, I would take it that he's accepting it's his acceptance for the 2 tires, but I will need to know before midday if you want the 4 tires. That's the invitation to treat. He's putting it out there, and Jill has not accepted it, but she may. But she doesn't.
So, sorry, I had a problem hearing you earlier, Tim. Can you repeat what you said?
Sorry. So when Graham responds with okay, I would say that's his acceptance of the 2 tires. And then it's an invitation to treat when he goes on to say he needs to know before midday if you want the 4 tires. So he's putting it out there that you can get 4 tires on a special deal, but come back to me. Okay. So I would say that's the invitation to treat.
Okay, thank you. Now, before I respond to that, Tim, I'd like to go back to what Amelia stated earlier, that the fact that the tires were on display actually constitutes an invitation to treat, and that it is not a binding offer. Would you agree with that?
Yes, yes.
Okay, why would you say that? Why can't a customer just come and say, I'm accepting this offer? What's the difference?
Is it because the tires are on display and it's on display for a large audience to accept the offer as opposed to just one person?
Mm-hmm. Would it make a difference whether or not the tires on display did not have any prices on them? Would it make a difference or not?
No.
Okay, so that's good. I would tend to agree with that there is in fact an invitation to treat in that case. So the only time you may say that there is in fact an offer will be when the customer, for example, tells the cashier or the owner that she's interested in buying the tires. But the mere fact that the tires are on display, and even with the prices there and all the technical specifications next to them, that should be treated only as an invitation to treat. So in other words, a customer coming in cannot just unilaterally bind the owner of the shop by saying that, you know, I'm buying this, I'm accepting your offer, and get this specific tire or any of these tires. So that's an invitation to treat. Now, so Tim also was suggesting that there was another indication that there is an invitation to treat. And this was in relation to the statement by Graham that I need to know before midday. If you want the 4 tires to be done. Okay, would that be it? Would that be the one that constitutes an invitation to treat, or is there something else there?
I believe Graham's making a counter offer there.
Okay. Now, if it's a counter offer, then we're saying it's an offer, but not an invitation to treat. So which one is it? Is it an offer in the sense that is it a counter offer, or is it an invitation to treat? So the statement by Graham, okay, but I will need to know before midday if you want the 4 tires to be done. Is that an invitation to treat as suggested by Tim, or is that a counter offer?
Wouldn't it be a counter offer because an offer has already been made of Jill purchasing the tyres? So that would then constitute as Graham responding to her as a counter offer.
Okay, if that is a counter offer, so if we're in the first place, if we're suggesting that it is a counter offer, then we're essentially saying it is not an invitation to treat. Are we clear about that? It can't both be a counter offer and an invitation to treat, because a counter offer is still an offer and it's binding. If it's accepted, you have a contract. If it's an invitation to treat, there is no valid offer. Tim, did you want to say something?
Couldn't we say that because she accepted the 2 tyres, and he said okay, wouldn't that distinguish the 4 tyre offer?
Okay.
So if the fact that she's taking the 2 tyres, the following 2 tyres is essentially a new contract, almost.
Okay. Before I answer the question, I would like to go back to that point. When we say that there is a counter offer, we're assuming that there is an offer. You can't have a counter offer without an initial offer. The question is, what exactly is the offer that was the basis then of a counter offer?
So wouldn't the initial offer be Jill saying to Graham she will purchase those tyres and him accepting that, and then he would go back to her with the counter offer in regards to the 4 tyres?
Okay, so let's be more specific here. What exactly was the offer in relation to the number of tyres? Was it?
So Jill purchasing 2 tyres.
So that was the offer?
The first offer, yes.
But I thought there had already been a contract on that because Jill accepted it. I thought we agreed initially that there was a contract in relation to the 2 tyres. So if there was a contract already, how can that initial offer that was then accepted then become the second offer?
It's not the second.
Were there 2 offers or not? So let's begin by asking that question. Was there just one offer, or were there 2 offers here? And what exactly were they?
Just the way I saw it was that Jill ended up, she went into the store and made an offer to Graham to purchase the tyres. So I saw that as the first offer, followed by Graham made a counter offer with the special deal for an additional 2 tyres. And Jill then went and adjusted the terms for the first offer and pretty much set up a second contract by saying that she would go back and look at her finances for the second 2. So, yeah, I think there's about 2 offers in there.
Okay. So let's clarify this. In the first place, was there a contract between Jill and Graham? So we're going back to question A. Was there an offer that was accepted?
Yes.
In relation
to the 2 tyres.
Okay, good. So we're clear with that. If there has already been an offer that has been accepted and there is a contract, is it possible actually to accept that same offer as the basis for a second contract?
No.
No. Okay, so if we're saying that there is a counter offer, that counter offer was in relation to what? Was the counter offer in relation to the 2 tires that Jill was initially offering to buy, or was it in relation to something else?
So there would be a second offer for 4 tires.
Okay. So there is, in fact, a second offer here. And that second offer, which is a different offer altogether, relates to the 4 tires, not the 2 tires, over which a contract had already been entered into when Graham accepted the offer of Jill to purchase those 2 tires. But the second offer here was the offer made by Graham to sell to Jill 4 tires. Okay? And then Jill made a counter offer saying, I'll check my finances. Okay? Now, so we've answered question C, and it would appear that on the basis of the facts, the statement on the part of Graham that, okay, I will need to know before midday if you want the 4 tires to be done, is not actually an invitation to treat in this case. It constitutes a counter offer. So in other words, if Jill accepts the initial offer by Graham to sell the 4 tires at a reduced price, then there would have been a contract. Now, the question, though, that I would like to ask is, in relation to the statement by Graham that he was willing to have a special deal by giving 4 of those tires at a lower price per tire, is that actually an offer, or is that an invitation to treat?
It's an offer.
Why is it an offer?
Because he's displaying an intention to be bound. If Jill said, all right, then they would have a contract. If it was an invitation to treat, there wouldn't be a contract on the basis of that.
Okay. Now let's clarify something about the nature of an offer. When you speak of an offer, is it possible to accept an offer that is actually vague or is uncertain? Or is there a requirement that the offer must be at least specific or at least certain?
It must be sufficiently certain.
Okay, good. So we've cleared that. So for there to be a valid offer that can be accepted to constitute a contract, there must be an offer that is sufficiently certain. Now that statement here, that Graham was going to give a special deal by giving her 4 tires at a lower price per tire. Is that sufficiently certain? It's not.
It would only be sufficiently certain if they've actually defined the price.
That's right. So it's not sufficiently certain. Because, even if Jill were to accept it, what has she accepted? They don't know the price, and the price in this case, obviously, is crucial to having a contract. So in that sense, that statement can actually be looked at as an invitation to treat instead of an offer. Did somebody want to make a statement? No? Okay. So where are we now? Yeah, so because that statement is an invitation to treat, the statement that Graham was willing to offer a special deal by giving Jill 4 of those tires at a lower price per tire, it was not susceptible to an acceptance by Jill of that as an offer that would then have led to a contract. What Jill needed to do was to actually make an offer as to what the price would be, or require Graham to be more specific as to the prices of those 4 tires. Without any of those happening, without Jill making an offer as to the price, or without Graham providing a more specific, a price that was specific in relation to the 4 tires, all you have will just be an invitation to treat that, even if acted upon, would not lead to a contract. Now,
Manjo, could it be potentially
considered to be an offer because she knew the price of the first 2 tyres, like that was considered upon, and she was happy to obviously go ahead with the price of 2 tyres, but then he said he was going to give 4 at a lower price, so any reasonable person could expect that a lower price would be better than the original price, so therefore she had an indication of what the pricing would be and that it would be better.
Okay. The question really here is, when we speak of the offer, are we speaking of the offer in relation to 2 tyres or in relation to the 4 tyres?
That was about the 4 tyre thing being an offer rather than an invitation to treat, like having more certainty about it being an offer with regards to the whole pricing thing. Like it's not like she had some idea of the pricing.
Yep, but in relation to the 4 tyres, what exactly was the price? Was it the price as indicated on the display, or was it a different price?
I think because he was indicating that it was going to be a lower price per tyre than what was originally advertised and that she had agreed upon for the 2 tyres.
Sorry, I kind of missed that.
Sorry, I meant like it was a lower price than per tyre than what was first advertised for the 2 tyres that she had agreed upon. So it's specific in that it would be a lower price per tyre than what previously was agreed upon, and you would think that that would be a better offer in general. So she'd have an indication of that price and that it would be something that a reasonable person would be likely to accept if they decided to go ahead. I guess it's not as vague as if there was no price originally displayed at all.
Okay, but let's focus on that point about that there be a lower price for the 4 tyres. If you were Jill, how much is the lower price in that case? In relation to the prices that are on display, would that be sufficiently certain to you, or even sufficiently certain to Graham? So you have a listed price which you can see, and then there's an offer on the part of Graham that he was going to reduce or sell those tires at a lower price. What exactly is the lower price? Is that sufficiently certain? How do we know what is the lower price?
The lower price realistically could be anything. Like it could be 1 cent different per tyre, or it could be $100 per tyre.
Exactly. And in that case, if we say that there wasn't a contract, and let's assume that Jill at some point wanted to pay for the tires, how will we know how much Jill would have to pay for the 4 tires? If assuming we accepted that was in fact an offer that Jill had validly accepted to get the 4 tires, how much is Jill supposed to pay? And who's supposed to determine that? Was there actually an agreement on the part of Graham and Jill as to what the price would be for the 4 tires if Jill actually bought the 4 tires? No. Would a court actually be in a position to say, to construct the agreement as to the price? Would a court be in a position to say how much the price would be for the 4 tires? No. So therefore we can say that as far as the price was concerned, which was crucial to this contract, it was not sufficiently certain. And we know that an offer, for it to be validly accepted, that offer must be sufficiently certain. Because otherwise, you don't know what the respective rights and obligations are of the parties. You wouldn't even know if there would have been a breach of contract in this case. So because as far as the 4 tires are concerned, we don't know how much the price is, what the effect would have been was actually on the part of Graham, either to suggest to Jill that she offer to make an offer as to what the lower price should be, or for Graham to clarify his position and then state what he actually meant when he said lower prices. In the absence of either of those two happening, what you have is an offer that is uncertain and therefore is incapable of being accepted, that would then give rise to a contract. Now, in relation to D, if there is a contract, so we kind of discussed it, is it for the replacement of 2 tires or 4? So we said the contract was in relation to the 2 tires. Could it actually also have been in relation to 4?
Manjo, could there been a option contract made in relation to leaving, like letting Jill having to let Graham know that if she wanted the 4 tyres before midday.
Okay. What is the implication of that statement? I asked that question because we had initially said that there had been a contract in relation to the 2 tyres. So if there was a contract, we should know when that contract was consummated or entered into, or when the ad idem happened, or when the meeting of the minds happened. So we cannot say that there was a contract and then, oops, there was no contract. So was there a contract for the 2 tyres or not? Because if there was a contract for the 2 tyres, then you cannot make an argument that there was an offer to sell 4 tyres actually.
I think I meant, like, obviously there's the initial contract for the 2 tyres, but where Graham makes the offer for 4 tyres and having to let him know before midday, I've just read in the notes that there's things such as like an option contract or an option clause where if they had stated something that I'll leave this offer open to you until midday,
yes,
that's partly bound as a contract.
Yes. But that leads to the question of whether or not you actually have 2 possible contracts. Meaning
yes, so you'd be having 2 contracts.
Yes. So if there are 2 contracts, it actually means that you've got one that might potentially already have been accepted, so that in relation to the other one, you actually have a potentially separate contract and a separate offer in that case.
Yes.
Okay, so if we are in agreement that there was initially a contract between Jill and Graham in relation to the 2 tyres, if there had already been an agreement to that effect, then any other actions on the part of the parties later on couldn't possibly change the contract because there had already been a consummated contract.
Yep, I understand that. But then is there a second contract made with him offering to keep the extra, like another 2 tyres open to Jill until midday?
So the basic question that we ask here is, can you make an argument that there was in fact a potentially separate agreement, meaning there was a second offer? What exactly was that second offer? If we assume that there had already been a contract that had been consummated or entered into in relation to the 2 tyres, if there had already been a consummated contract, what then was the potentially separate agreement, and what exactly was the offer of that second potential agreement? Because remember, if there is a second offer, it could possibly be withdrawn by the offeror. That's the other thing. But if we make the case that there had already been a contract, then there's nothing to withdraw because the contract had already been entered into. So what exactly is that second offer there? That's right. So from Jessica, it is in relation to purchase two more tyres before 12 noon. Okay? So even if it appears that there was actually a second offer to kind of sell 4 tyres, that's not really true. There had already been an agreement that the first 2 tyres were going to be sold. So if there was a second offer, the second offer was in relation to the other 2 tyres. Okay, not the 4 tyres, because the first 2 tyres had already been the subject of an agreement, had already been the subject of a contract. So in relation to the first 2 tyres, there could be no withdrawal by either of the parties, because that was already a valid and binding contract. So if there was a second offer, it had to be in relation to the next 2 tyres. Okay, so that should be clear. Now, so if there was an attempt on the part of Graham to withdraw the offer, what exactly could he possibly withdraw? Was it the offer in relation to the 2 tyres, or was it in relation to the 4 tyres? So you can see the connection there.
He could offer to withdraw the 2 tyres, but the second lot of tyres, but not the first lot.
Why not?
Because he'd already agreed to the contract for the first 2 tyres, but he'd put a time limit on the offer for the second lot of tyres.
Very good. So you can see the importance there of having established that there had already been a contract in relation to the first 2 tyres. Because there had already been a contract in relation to the first 2 tyres, Graham was not in a position to actually withdraw an offer in relation to the 4 tyres. He could only withdraw his offer in relation to the last 2 tyres that he had initially offered to Jill. Okay, clear enough? Now, so we go to that question. Was Graham's attempt to withdraw his offer in relation to the last 2 tyres successful or not? Why or why not? So that's the final question here. So we're now speaking only of the last 2 tyres. Was Graham's attempt, because he eventually sold the 3rd and 4th tyres to somebody else, when he did that, was he in breach of a contract?
I don't actually believe Graham was successful in his withdrawal of the offer because they hadn't actually established a way for them to communicate in how they would, if something occurred, they would be able to withdraw the offer or accept it. So I don't believe he was successful because those terms weren't actually established in their conversation.
Any contrary viewpoint from anyone? From Sophie, she says the withdrawal was successful. Tim, you wanted to say something?
Yeah, he made a reasonable effort to withdraw the offer. There was an issue with his SMS and whatever, but he made best effort.
Okay.
A reasonable effort.
Yep. But that's good. Now, but let's make a clarification first. In the first place, did Graham actually have the right or the power to withdraw his offer in relation to the 3rd and 4th tyres? Could he actually do that unilaterally, or wasn't he bound to honor his commitment to Jill that he was going to sell, the last 3rd and 4th tyres to Jill before midday? Did he have the power to actually withdraw that offer?
Well, yeah, I would say he did. He did have the power to withdraw.
Why is that? So what's accepted in relation to offers?
It can be withdrawn at any time before acceptance.
Very good. So the general rule, therefore, is that if there is an offer, the offeror has the power to withdraw the offer anytime before acceptance. So that's the general rule. So in this case, Graham could do it. Now, when might we say that there might be a breach if the offeror withdraws his offer prior to the offeree accepting or being given the opportunity to accept the offer? So would there be instances when an offer cannot be unilaterally withdrawn by an offeror?
I would say yes. If it would depend how specific it was.
So when might you say that an offer cannot be unilaterally withdrawn by an offeror? When might you say that an offeror cannot unilaterally withdraw an offer?
If the condition was more stringent, say this offer is open until, oh no.
The answer to that, because I'm looking at the time, and you might have other classes, and I've actually got another one. You would be able to say that the offeror cannot unilaterally withdraw the offer if there had been consideration for that specific offer. Because in that case, you might say that there is a contract between the offeror and the offeree for the offeror to maintain that offer until such time that the offeree is given an opportunity to exercise his rights under the contract. So if there had been a consideration on the part of the offeree, that would then enable the offeree to exercise his option to act on the offer, then in that case, the offeror cannot unilaterally withdraw the offer. Now, so going back to this question, Was Graham's attempt to withdraw his offer successful or not? Why or why not? Because some say that, there was no So what's the answer here? Was Graham's attempt to withdraw his offer successful or not? There seems to be a disagreement as to what the correct answer should be. From Amelia, can't withdraw after accepted. Okay. Was there actually, in the first place, was there a valid acceptance on the part of Jill of the offer of Graham to sell the third or fourth tires to Jill? So even assuming that Graham did not send a text message, we'll make an assumption that Graham did not send a text message. Let's just assume that Jill, in fact, phoned Graham and left a message on his answering machine. Let's just make that assumption. Can we say that if Jill did this, she phoned Graham and left a message, can we make this, the assertion that that there was a contract and that the offer had been validly accepted? So
I don't think so, because wouldn't they need to still work out the pricing details and all of that?
That's right. So one of the problem there that we're being faced with is the fact that how can there be an accepted offer if we don't know what the price is in the first place? So that's one. But what is the rule in relation to an acceptance of an offer? What is the rule there? Do you know my question? Do you understand what I mean by my question? What is the rule in relation to the acceptance of offer? So in particular, is there a need for that acceptance to be communicated to the offeror or not? Or is it sufficient that the offeree accepts the offer without actually informing the offeror? Or is there a requirement that the offeror must be made aware that the offer has been accepted? What exactly is the rule? Okay, so the rule is, as pointed out correctly by Jessica, for an offer to be validly accepted, that offer has to be communicated to the offeror. In which case here, we might say that the communication of that acceptance, assuming that the price was agreed upon, would have failed because it was left on an answering machine. Okay, because it's 7:06 and I assume others will have classes and we've got a class in a few minutes, I think we've sufficiently answered the tutorial questions. If you have any questions, feel free to, okay, let's just answer the question from Luke. But does an answering machine count as a third party? What does that mean, Luke?
Just because I was reading that you can actually accept an offer via a third party,
Yes.
just in relation to one of the scenarios I read.
Yes.
So if I was just wondering if the answering machine can be counted as a third party in letting know that the offer was accepted.
Yeah, not really as a third party, but more as a means of communicating effectively the acceptance. Okay. In this context, it's difficult to argue that it's difficult to make a claim that Jill's act of leaving a message on the answering machine would have constituted acceptance, of which there was knowledge on the part of Graham. Mainly because the requirement is that for there to be an agreement or a contract, there must be a meeting of the minds between the offeror and the offeree. In this case, in this scenario, they're at cross purposes because on the one hand, you've got a situation where Graham was saying, I'm no longer selling you the last two tires, which wasn't relayed properly to Jill. And then you have an instance where Jill is saying, I'm accepting it. So even assuming that Graham actually sent a text message to Jill saying that he was willing to sell the last two tires at a specific price to Jill. But that was sent through a text message that Jill did not receive. And assuming that Jill accepted the initial offer based on a price that was agreed upon using their answering machine, there would still have been no meeting of the minds. Because one was based on a text message that had not reached its intended recipient, and the other one was based on a message left on an answering machine that also was not accepted by the offeror. So there cannot be a meeting of the minds. If there is a meeting of the minds, it has to be at the same, using at least the same medium in this case. So the mere fact alone that there was actually an acceptance by both of them would have been insufficient. Because on the one hand, there was a failure in relation to the attempt on the part of Graham to explain to Jill that the offer had been withdrawn. And there was a problem in relation to the acceptance by Jill because she only left a message on the answering machine. Okay, so we'll end tonight's session with those discussions. And as I mentioned, I've already posted the legal memorandum assessment in Moodle on Saturday. And so I hope to see you again next week. So thanks for joining all of us. Thank you. Good night. Sorry, Heidi, I'll get back to you on that. I may have missed that. That's right. I'm going to get back to your question on the assessments. Okay, thank you. Good night, everyone. Bye.